Welcome to Immigration Q&A with Attorney Estee. I'm Attorney Estee Aceron Bisnar. I'm practicing immigration law, family law, and property and estate planning here in California. And I'm also licensed to practice law in New York and Philippines. In this segment, I will answer questions about U.S. immigration law. So if you have questions, feel free to email me at attorneyestee@aceronbisnarlaw.com, and I will do my best to answer your questions through this segment. Let's get started with our question for this episode. The question is from Miss Mary C. of California. Attorney Estee, I am married to a U.S. citizen and I would like to adjust my status here in the U.S. What are the requirements and the documents I need to submit with my application? Thank you, Miss Mary. Thank you for your question. You need to submit Form I-485, which is officially called the Adjustment of Status Application. It is also known as the Green Card Application. To adjust the status, you'll have to be here in the United States and submit Form I-485. Since you are married to a U.S. citizen, your spouse can petition you using Form I-130, Petition for an Alien Relative, and Form I-485 concurrently. Those applicants who are not present in the United States can apply for green card from their home country through the consular process. But not all applicants who are married to a U.S. citizen can adjust their status or apply for green card. You cannot file an I-485 if, among others, you came into the U.S. as a crewman, you came into the U.S. while in transit to another country, you are in removal proceedings due to terrorism. There are also inadmissibility grounds that may prevent you from filing Form I-485, such as criminal record. A court convicted you of particular crimes, security grounds, you pose a threat to the national security of the United States, or for immigration law violations, like you've previously violated U.S. immigration law, and for example, health-related conditions. You have a mental health condition or a disqualifying communicable disease. There are also other grounds such as entering the U.S. to practice polygamy, child abduction, and to vote unlawfully. However, waivers may be available to resolve some of the inadmissibility grounds. Obtaining a waiver is not that easy, so it is always advisable to consult with an immigration attorney. Now, for my clients in a family-based category, particularly an applicant married to a U.S. citizen and filing the I-130 and I-485 concurrently with the application for work authorization and, of course, the affidavit of support, I would ask them to send me the following: passport-style photographs for both petitioner and the beneficiary, copy of petitioner's certificate of naturalization or U.S. passport or birth certificate, marriage certificate of the parties, beneficiary's birth certificate, beneficiary's passport, beneficiary's U.S. visa used in entering the U.S., beneficiary's I-94 departure order, petitioner's income tax return for the most recent year with all its attachments, petitioner's pay stubs for the last 3 months, petitioner's W-2s or 1099s for the most recent year, dissolution of marriage of beneficiary with previous spouse or spouses, dissolution of marriage of petitioner with previous spouse or spouses. And this is important, documents showing commingling of assets. For example, certificate of title of a spouse's automobile and other assets, or car insurance policy in both the spouse's names, the spouse's joint bank account statements, your mortgage payments showing both your names, the utilities bills in both your names, life insurance policy designating the spouse as beneficiary, photographs of petitioner and beneficiary, with friends and relatives during their weddings, special occasions, your out-of-town trips, etc., etc. But my clients would always ask me, Attorney Estee, we do not have all these documents showing our commingling of assets. What shall we do? Well, I would always advise them to just submit whatever they have. In some instances, I would ask the petitioner to make a declaration or affidavit of good faith marriage that details how they met, their wedding, their day-to-day activities as a couple, their routine. This way, if they do not have sufficient evidence to show commingling of assets, they can explain their failure to submit those documents and also will be able to substantiate and validate their claim of good faith marriage. Sometimes, declarations from family members and friends about the couple would also help demonstrate the genuineness of the relationship of the spouses. As to how much does it cost to file I-130 and I-485, the filing fee for I-130 is $535 and for I-485 it's $1,140 plus biometrics fee of $85. So you need $1,760 for filing fees alone. That's it for now. Please remember this segment is to provide information and general views about U.S. immigration law. This segment is not intended to provide specific legal advice. Every case is different, and so it is always advisable to consult an immigration attorney. You can check out my YouTube channel at AttorneyEstee channel for more information about U.S. immigration law. If you have not subscribed to my channel, I hope you do so now. For a free consultation, you can email me at AttorneyEstee@aceronbisnarlaw.com or visit my website at www.aceronbisnarlaw.com. See you in the next episode of Immigration Q&A with Attorney Estee every first Friday of the month here at Spotlight TV on KSCI TV LA 18. Bye! Attorney Estee will be in the following cities: Chicago, September 1 to 3, Fresno, September 3 to 5, San Francisco, September 5, and New York, September 15 to 19. So email AttorneyEstee@aceronbisnarlaw.com to book your appointment now. Thank you!